breaking news is that Amber Heard has filed an appeal of the Johnny Depp verdict. This goes to the Court of Appeals in Virginia, and we'll take a quick look at what is an appeal in this situation. There are some kinds of appeals that are called de novo. So if you were in district court in Virginia and you appeal to circuit court, you get a full de novo situation. So they're just going to redo the case from fresh. That's not really what happens when it goes to the Court of Appeals. The Court of Appeals, there'll be assignments of error that Heard's team will say that the judge or the court made mistakes in these situations, typically on the law. That was an error. It had a material effect on the verdict, and so it should be overturned, either thrown out or a new trial ordered. That'll be what her appeal is about. The appeals court would consider that under what they call the applicable standard of review. That can range from a de novo review of how the trial court interpreted/applied the law, and it can extend all the way to extremely great deference to the fact finder in this situation, the jury or findings of fact, where they give a lot of deference. Somewhere slightly in the middle of that, but still tilted over to the other side, is abuse of discretion. So trial court doing various things during the trial, depending on what it is, could be considered to be reviewed only on abuse of discretion. In other words, even if they were probably wrong, the judge was maybe wrong, we're still not going to reverse this because they have a great deal of discretion. So depending on how the assignments of error are framed, will determine how the Court of Appeals looks at those, how closely they'll scrutinize them, whether they'll give them a lot of deference or whether they'll look carefully at it. So there are some issues of law that were raised in the motions that the Court of Appeals, if they accept those as assignments of error, they would look carefully at that. But if it's just generally attacking the jury verdict, of course, that's not going to be favorably looked at by the court. Let's look at this Virginia statute that sets the framework for that. When a civil case is tried by a jury and a party objects to the judgment in refusing to grant a new trial or motion to set aside that on the basis the verdict of the jury is contrary to the evidence, the judgment will not be set aside unless it appears from the evidence that such judgment is plainly wrong or without evidence to support it. So that kind of standard is, if the jury was so wrong as a matter of law, it was ridiculous, the verdict they came back with, then it could be overturned. But the statutory reference sets the framework for this, which is we don't want to be retrying cases, and we don't want the Court of Appeals setting up there acting like that they should be weighing the evidence, that they substitute themselves for the jury, and they will not do that. So it's quite complicated how appeals work, but generally speaking, if there's a finding of fact, the appeals court is going to give it a lot of deference. Heat of the moment kinds of quick decisions the trial court has to make. Heat of the moment situations in trials, a lot of deference there. Important matters of law that may have put the case on one path versus the other, the appeals court will look more carefully at that. So as a general rule, with exceptions all over the place, the court's not going to sit up there and reweigh evidence. They're not going to look at this and say, wow, they probably should have looked at this more carefully, or I would have thought that was more important. They're not going to do that. What they will do is look and see if there was error in the courtroom, and then if there was error, whether it was harmless error or whether it was prejudicial and would have had likely an effect on the outcome of the case. That's important. And then also whether there are novel legal issues that perhaps the judge made a mistake on. Those are the kinds of things that will be reviewed. It's usually a tall order to get an appeal, especially if you notice lots of grounds for it. The court may have made a mistake or two. It's not likely that they made 100 mistakes. So this appeal should be focused. Haven't seen it yet. We'll have to see what the assignments of error are. But the important part is the appeal has been filed.